So let's say you've just been in a serious car accident. You're dealing with injuries, medical bills, pain, and now your employer is asking, when can you get back to work? What are your rights in this situation? Well, that's where the Family Medical Leave Act kicks in. And today we're going to talk about that and how it works in a personal injury case. So what is the FMLA? The Family Medical Leave Act, FMLA for short, was passed in 1993. And essentially, it prevents an employer from firing you just because you can't do the job because of a medical event. And it also crucially allows that you must keep your health insurance benefits. And that's a really key piece if you've been in a serious personal injury, like a motorcycle accident, car accident, whatever. You're going to need your health insurance even if you cannot get to work and do your job. So the key thing to know is it's unpaid leave, meaning they don't have to compensate you. So your lost wages will still be part of the personal injury claim or the car accident or motorcycle claim. Your job doesn't have to pay you, but for at least a 12-week period, you are protected and they can't just give your job away or fire you because of the medical event. So your job is protected and your benefits continue. So what does job protected mean? It means your employer can't fire you, right? And when you return, you got to have at least the same job or one that is equivalent in pay, benefits, and responsibilities. And then, as I've already mentioned, crucially, they have to continue your health insurance on the same terms that they did when you were working before the medical event that required you to take the leave. So do you qualify for family medical leave? Not automatically, right? There are some eligibility criteria you need to know. First of all, your employer must be a required employer to provide this type of coverage, and that means 50 or more employees within 75 miles of your work site. That includes all private companies, all public agencies, state governments, etc. So they're all under that umbrella of employers that must provide FMLA coverage. You must have worked in your job for 12 months, and they don't have to be consecutive, right? So if you left your job, came back, it's the accumulated time that you've spent at that employer. And then you must have worked at least 1,250 hours during the previous 12 months, which is roughly 24 hours per week. So think about that. You don't have to be quote unquote full time. Even a 24-hour a week part-time employee is protected. So does your injury qualify as serious? Well, if you're watching this video, probably it does, but let's talk about what that means. So any condition requiring inpatient care. So did you have an overnight hospital stay? Incapacity of 3 or more consecutive days, so missing more than 3 consecutive days plus continuing treatment by a healthcare provider counts. Certain chronic conditions, PTSD is one of them, ongoing pain management, which might be very relevant in a personal injury context. And then just permanent or long-term conditions or multiple treatments, restorative surgery, that sort of thing. So say you've been in a motorcycle accident, car accident, and you have to have a surgery, and you need time off to recover. In the example I'm using, my client had a broken leg, and that's going to take some time. It's going to require multiple surgeries. And so, the Family Medical Leave Act is there to make sure that during all that period, even though she can't work, she can retain her health insurance benefits, and that will help cover her for all the necessary care she needs related to the accident. So there's 3 ways you can use your FMLA leave. Obviously, you can take continuous leave, taking all 12 weeks at once, but you can also do intermittent leave. Like if you know you're going to have multiple different surgeries or multiple different events, you can kind of plan that accordingly. And you can also do a reduced schedule. So working fewer hours per day or fewer hours per week as you kind of ease back into working. So you will need a doctor's note, right? Medical certification. What documentation do you need? They can and will ask for a doctor's note. This is obviously not going to be that big of a deal if you've really sustained a serious injury and had to have surgery in a car wreck example. There's going to be a note written by the doctor, but it must include the date that the condition started, the duration of your condition, how it affects your ability to perform your job, and how much leave is needed, and then just sort of medical facts. So there's an important little note here that for privacy reasons, the doctor does not have to tell your employer the specific diagnosis. If it's something that you don't want them to know about, you're entitled to medical privacy. It just needs to establish that you have a serious health condition, and a doctor's note is required to generate that. So under the FMLA, what your employer must do: return you to the same or equivalent position, maintain your health insurance. That's probably the biggest takeaway from this whole video, in my opinion, but you might get something else out of it. Continue the benefits while you're still working. Provide notice of your eligibility and rights. Designate leave as FMLA. Also, don't retaliate against you. That could be a completely different kind of case. That's an employment law retaliation case, but they can't, treat you differently or reassign you or do anything, dock your pay because you used FMLA. And to do that, contact an employment lawyer. So what employers can do, they can make you take your sick pay, your vacation time, any accrued paid leave as part of your FMLA, so that you will burn through all your vacation days if you have to take FMLA. As we talked about, they can require medical certification, require a fitness for duty certification if your job sort of involves that, kind of physical activities. I'm a lawyer, so I could, sitting at a desk is not really that hard for me, but obviously certain jobs you have to be a certain level of physical fitness to perform them. And, employers can require proof of that. So we talked about retaliation. What employers absolutely cannot do is fire you for taking the leave, demote you or reduce your pay, discourage you from using FMLA, count FMLA as an absence, and then, use that as a disciplinary thing, and retaliate in any way. And of course, what they really can't do is cancel your health insurance. So if they do any of those things, contact an employment lawyer. So let's talk about some common myths under the FMLA. It's paid leave. No, it's not. It is unpaid leave. You need to specifically say, I'm requesting FMLA. No, you don't. If you tell your employer you've got a serious medical condition, for example, I was in a bad car wreck, they have a duty to investigate whether it's FMLA, and they have a duty to tell you of your rights under the FMLA. Myth number 3 is that you can't be fired if you take FMLA leave. Now, you can be fired for legitimate reasons unrelated to your FMLA. For example, company-wide layoffs. If you do something else like misconduct, they can do that. But they can't fire you just because you were in a bad car accident or you were in a motorcycle accident. Now you have to have surgery and you can't work. If they fire you for that reason, that's unlawful. Another myth is that the FMLA protects your job forever. No, it doesn't. We've talked about it. It's 12 weeks that you're entitled to under the law. Now, there's other laws that might protect you. For example, the Americans with Disabilities Act. If you are so hurt in an accident that you then become disabled, well, that's a different thing. Now you're protected under a different law. But for now, we're just talking about the FMLA. So just keep in mind, 12-week limit. As we talked about, that 12 weeks can be spread out over the year or over a duration, so you don't have to take it all at once. We talked about this myth that only full-time employees qualify. That is a myth because, of course, you can be a part-time employee and be covered under the FMLA. We talked about it's effectively 24 hours per week will entitle you to that. Now, we're kind of contradicting ourselves here because we said at the top that you don't have to use magic words to specifically request FMLA. And then the next myth is that your employer will automatically tell you. They're supposed to, but they might not do it. So, employers should provide notice, but you may need to affirmatively request leave. And if you have been in a serious accident and cannot work as a result of that, you might want to affirmatively request that just to make sure you are protecting yourself. So here's how the Family Medical Leave Act works with your personal injury claim. Let's say the accident happens and you suffer a serious injury. The FMLA will protect your job for up to 12 weeks, and during that time, you get full health insurance benefits that you had before the accident. This allows you to focus on your recovery without the pressure to return to work immediately. Of course, you're probably going to feel the financial pressure because FMLA is unpaid, but your employer can't threaten you that you're going to lose your job if you don't get back to work immediately under the FMLA. You are protected for up to 12 weeks. And in the meantime, that's where we come in as personal injury lawyers. We will pursue the injury claim. We'll get all the medical bills, lost wages. We'll document your pain and suffering. We'll get a demand letter out and try to get you a recovery as quickly as possible. And then when you return to work, medically cleared, you get your old job back or the equivalent job, same pay, same benefits, and the employer can't not give that to you just because you were in a serious accident. So if you've been in a serious accident and have questions for us, I'm going to put a link in the description. You can tell us about it. Thanks so much for watching.